So now we will start with the main topic of today's class. And here we says that the syllabus area, if we just quickly get it through down, what are the things that we will be learning? The second portion of this part, the second part of the chapter, what are the areas that we going to cover? We will be learning about the major areas, the arbitration, right? So you will be learning about the alternative dispute resolution mechanism, and the main thing will be this arbitration. So this is one of the process where you look around the alternative to the court. Okay. So explain the operation and evaluate the district merit of court-based adjudications and the alternative dispute resolution mechanism. I have taken an example of adjudication, the process, the court-based adjudication is basically when you go to the court just to resolve the doubt that you're facing. So imagine two parties are disagree on something. Maybe it is a contract issue or payment. Adjudication is where a neutral third party like a judge or tribunal listen to both sides and make the formal decision to settle it. This is basically the process of adjudication. So adjudication can be the arbitration one, or either it can be the court one. When you say about the court based adjudication, it does mean you are going to the court to resolve get resolved with the issue or the problem that you need. Then we will learn about the provision of ancestral model law on international commercial arbitrations, and then we'll learn about the arbitral tribunal and what the tribunals are, and explain what is an arbitral award. Award is basically what one party would be having after winning one or winning the case or winning that. So basically, what are the resolutions? Okay, the resolution the parties were looking for. Business are no longer limited to nations or state boundaries. Trade or contract occur between the various countries. This is so true. To make this global market a smooth, stable, and secure one, there are several bodies, laws, and regulations or agreement in force. We will discuss some prominent bodies in this chapter. Prominent are made of the major areas, right? Or major bodies. But before that, there is one thing. If you can able to see this, that to make this global market a smooth, stable, secure one, there are several bodies, laws, and agreement into the force. So when a market would not be a smooth, stable, secure, it would be because of the conflict of interest. Yes or no? To resolve or bring it into the smooth, stable, or secure one, we have to resolve the conflict both the parties would be having. Okay, so we basically talk about the possibilities of conflict. Okay, you do not wait to occur the conflict between the two parties. There is a law which is made already just to deal with it. It would not be that every time you are bringing or making a contract, first you will see that what is the conflict that we are having. No, if you're getting to the market of the international market, so you will get yourself applicable to the international law, because those are the ones that are made accordingly, keeping everything inside. Okay. Hello. Done?
Yes, sir.
Understood what I mean to convey? Like, it would not be like that every contract you are making, you will first see what are the rule that I can follow, what are the rule other can follow. You will just directly go to into the international market, because ultimately, simultaneously or vice versa, the international market in the country would not be having a major difference. Like, you know that the tax of the UK has further followed into the India, USA, right? So the concept are same. Even in the law that you will study in the ACCA or the CPA, other courses, the concept of the law, the criminal arbitration process, the court-based adjudications are the same meaning, right? So what I mean to convey, in order to make the market the place where you're making a transition a smooth, stable, secure one, you will always rely on the into the international market regulations, or will ensure that you are in line with what the several bodies or rule and regulation bodies would be saying to you when you're making an international market. Because ultimately, businesses would not be wasting their time, first of all, while making an agreement or looking for an agreement. First, look what are the term and condition we can agree on, then we will look after into the international market. So they just directly try to save their time, because business is the most expensive thing for a business would be a time for them. So basically, we just try to save their amount or amount by the time. So they just go and follow the international law when they're making into the transaction, because ultimately international law or these other agreement which are there, international law or those other bodies or several bodies are the last resort. Okay. Last resort as in when it comes to the conflict or the issue. But ultimately, to be a safer side, most of the people or the countries who basically making a contract across the boundaries would be following the last resort or the rule and regulation of the international bodies. That's what the international law is about. Now, if we talk about the need and what are the sources that we will be having the international law from, so when people from different legal system trade, there are bound to dispute sometime. Same thing which I have been very vocal about from the starting of the class. Since they have a different legal systems, they have internationally laws as common law, common system for all the international businesses. Understood? So what are the sources are there? The international treaties and conventions, the shared rule, conventions, international customs, what is happening into the international market, and then we will look around what are the principles, general principles that we do. They are the two things other than that, the public and private law. Just understand from here, public international law will be the rules that govern how countries deal with each other. So there is a concern or the focus is on the countries because it is a countries, so they are talking about the public. When I talk about the private, so rule for resolving dispute between the people or business from the different countries. Okay, so you will be having the public international laws. They will be talking about to govern the contact between the different countries. But when I talk about the private international laws, so you will be talking about resolving the dispute between the different people or the businesses from the different countries. Is that okay?
Yes, sir.
Private international laws, these are domestic laws. Yes, they are basically laws about how will a country deal with international laws. They define in which case and how much will international law overrule domestic law and vice versa. So this is a line when I was saying that the possibility, I hope you remember the example when I said that now the international law will ensure that the law of the India that the project can only be sold to the consumer will limit. The international law will be saying that this product when it will be sold into the China, they can allow or they have to allow them. So this is basically the overrule of the international law over the India law. Okay, so they are the possibility or inside the public international law, this is already stated like what is the possibility of getting the overrule by the domestic law or by the international law or vice versa. Is it okay? When I talk about the public private law, they basically having the treaties, conventions, and basically customs as well, accepted by various countries. It could be for the trade, travel, and military. Okay. Is there any doubt till now? Hello, both of you, Siddhant, Samvit.
Okay.
Hello,
No, sir.
done. Samvit, you okay now? So, what is the conflict of interest? Conflict of law? Would anyone of you please read this?
Conflict of laws will arise when the law of two different countries produces different outcomes, making it difficult for parties in those countries to trade with one another.
Okay. So, what do you understood from the same sentence which I just read it out?
Two countries. So because we're dealing with the laws of two different countries, there's a chance that there might be two different outcomes. So both countries will want something different, and that will make it difficult for them to trade with each other because they will both want their consequence or like their law to be the main one.
Done. Thanks. Now we will learn about what are the international treaties, convention, and model, and we will move to the what are the bodies or regulators are there. Okay. Public international laws arise out of the problem of the conflict of law. Okay, understood? Something I told you in the start of the lecture. National negotiation treaties and model codes so that parties can refer to, to that agreed code of conduct when carrying out international trade rather than their own domestic laws. So nations negotiate treaties and model codes so that parties can refer to that agreed code of conduct when carrying out international trade rather than their own domestic. So this is what they are talking about. That it is obvious that when they're making international transactions, so they have to use the international, they have to be in line with the international trade and regulations. So They will be negotiating, they will be looking after, they will be reading or observing what the national treaties and model laws, right? By the negotiation, they will look around what is exactly the same thing, what is the difference with the domestic law and into the nation, into the international laws, right? Okay. Negotiation is looking after the difference, what is that between the two, domestic law, international law, and what is the side of the international law that we have to follow. So this is basically the negotiation that we basically put on. India, USA, Australia sign a discounted tariff trade deal. So is this of a country or a business or some private individuals? It is because of it is for the countries, right? So that's why it will become the public private law. Is it okay? From here onward, we will be learning the international bodies, and it becomes important for you to remember some of the key points of these bodies, because these bodies, they will be giving a sentence of each body and they will ask you which body is that. It could possible that a question might be incorporating a statement, a summarized statement of this, and then they might ask you which body we are talking to. Okay, so the question would be like that. If we talk about the international organization, the United Nations. So United Nations is a global body which has almost every country in the world has member, which exists to maintain the peace, security, develop friendly relations between the two nations, cooperate in solving economic, social, cultural, humanitarian problems to promote the respect for human right and international freedom. So what is the United Nations? So it is basically the one of which every country almost is a member. First thing. Second thing, it exists to maintain the peace, security, and develop friendly relationship between the nation and to cooperate into the solving. So there are the two statements which you have to remember, that it exists to maintain these things and it cooperate for these things. So it could be that a caution might be there and they might say that it exists because of what? Because of the peace, security, or develop friendly, or because of economic, social, culture. So what you will be choosing? If it says that it exists because of what? Peace, security, or develop friendly, or to solve economic, social, or cultural problems. So the best answer of this would be the 1 or 2. Hello.
Yes,
Siddhant, Samvit, I want you to know a question would be there, and it says that United Nations exists is because of peace, security, develop friendly, or to cooperative in solving the economic and social culture.
Both.
Both. But if one of them would be there, so which one you would be selecting? You will be selecting this one, whatever the one option. But if it asks you that the best possible answer in the question itself, that what is the best possible answer for the existence of the United Nations, in that case, which one you will be selecting? The first portion, that isn't to maintain the peace, security, and develop friendly, or to cooperate in solving the economic, social, and culture.
peace, security, and friendly relations.
So why you have got this? Because you are focusing on the word, right? And the law paper, focusing on the word is essential and is an important thing, to be very honest, because this can lose easy marks. If the question would be asking you the best answer in line, and if you be selecting the cooperating one, you will be losing the 2 marks or 1 marks, whatever the answer for. Although you know this is the correct answer that you're selecting, but you are answering to the different line. They do cooperative, they help in the corporations, but in solving the economical, social, and culture. But the main reason for the existence is to maintain the peace, security, and develop friendly. Okay, so you have to be focus on the words, the keyword, and what is written over there. Okay, focusing on the words is essential and important for your law paper. Done. Through its various subsidies, courts, the United Nations has greatly facilitated international businesses. So United Nations would be having different bodies, and they have a different subsidies through which they basically look after managing or facilitating the international business, right? So its legal department would be incorporating two things: UNCITRAL, that is uncommissioned or uncommissions on international trade law. This is again a body, but a body that is in sub body of the United Nations. So remember this. Second thing, ICJ, that is International Court of Justice. UNCITRAL, with its 61 member state, has passed several treaties and conventions and law to make the global trade more secure and efficient. It is a 6 working group. Okay, so it could ask you how many group are there. It would be the 6 working group. First thing, 61 members. Okay, and why it is there? It is there because of it has passed several treaties and conventions and law to make the global trade more secure and efficient. If we are talking about more secure and efficient trade, so we will be talking about the unfair trade. Understood? Are you able to understand what type of the question would come up from this area or from the international organization? Are you able to understand what I mean to convey from here? If you look to the other area or other body that we do have, that is known as the International Chamber of Commerce, that we'll be talking about is an organization created by business leaders from various countries which aim to serve world business community by promoting trade and investment, open market for goods and services, and free flow of the capital. So whenever there will be a discussion about the free flow of capital, investment, open market, good and service, and just a mean to serve the world business community. So for what we are talking about? We are talking about the International Chamber of Commerce. Okay. Understood? Guys, are you able to understand?
Yes.
They help in ease of doing international business and also advise the union. So a question would be there and they might ask you which party advise, which body advise the United Nations. So what will be your answer?
International Chamber of Commerce.
Okay. A question would be there. They will be asking you that who is the chief authority of ICC? World Council.
World Council.
Okay. So these are certain things which you need to remember and keep. I know are little heavy talks, but this you have to do for your law paper. Okay. Okay. World Council has an executive board of 15 to 30 members elected for 3 years, and with 1/3 members going to be retiring each year. It does mean that 1/3 of the board got replaced every year. Okay. And they basically make the ICC policy. So who is the one who makes the ICC policy? So it will be the World Council. Okay. And again, these are the one, the chief authority of ICC. So World Council is what? World Council is basically the one who makes the ICC policy, chief authority, and they have a member of 15 to 30 members. And for 3 years, those are elected for 3 years, and 1/3 basically got what? Replaced by other for every year. Okay. Hello, done?
Yes, sir.
World. So this is something a different one. This should have been this one. Okay, make a correction over here. World Council also elect the chairman or vice chairman who make the recommendations to the board. National committees represent the ICC in their national state. The secretary headed by the general secretary ensure the implementation of the ICC policies member. I know both of you would be thinking that what we're reading might be going above your head, but this is something that we have to remember. Something giving a constant revision of the same thing will help you in remaining or keeping these definition, because ultimately you have to remember these things like who basically does what. So this is the thing that you have to remember, something we cannot learn in the class and something I cannot explain beyond that. Okay. Then we have a World Trade Organization, that is another body that we have. Okay. And who is a World Trade Organization? It is an organization which provide the rules for systems of the international law. It was formed from the old General Agreement on Tariff and Trade. So this is basically the replacement of GATT. Okay. World Trade Organization provide guidance on trade in goods, services, inventions, creations, and intellectual properties. One thing is sure, one thing is important, or one thing will make easy for you is that in the law they will giving you the exact definition of the same thing, because in law a replacement of a word slightly from one place to another would be changing the meaning of that. So the possibility of seeing the same statement that you're seeing here will be higher in your law paper. Okay. But ultimately, you will see that those are the things, they will form it other way around. They will give you the question that will, because ultimately the difficulty of the ACCA paper is higher one, so they will not give you the exact definition, but ultimately you will see that they won't be major changes, because changing a word place would mean a different thing when you will read it from the both, in the context of the both things, right? From the, in the context of both the places when the word or place are there. When we talk about the World Trade Organization, so it would be having a member, 149 members, who are basically accountable for 97% of the global trade. So these are member 91, 94 members. It does mean they are the different countries. They're talking about the 149 different countries who basically look forward to the 97% of the global trade. Okay, so we can say that 149 countries are the one who are looking after the 97% of the global trade. It's Brad aim to improve the global trade ecosystem. So a question would be there, what is basically the aim of the World Trade Organization? So what will be your answer? Obviously this will be in the option, but you have to select one. So what will be your answer? If it says that it is an aim of what? Why I'm talking about the World Trade Organization. So what is an aim of the World Trade Organization? It will be to improve the global trade ecosystem. Okay. World Trade Organization is basically the highest authority that we do have for the management and regulation of the trade. But again, a sub body of United Nations. Okay. Appeals are heard by 3 members of the appellant body. Appellant body is basically supposed to be the higher body, higher level body. Okay. And when you are making appeal from one place to the higher one, this is known as an appellant body. Okay. This one. If we talk about the Organization of the Economics, Cooperative and Development, so they talk about a group of member countries whose modern aim is to be a forum for discussing, developing, defining economic and social policies. Okay, as the name says, it's organization which talks about the economical cooperations and development. So this is what OECD is, a group of member countries whose modern aim is to be the forum for discussing, developing, redefining economic and social policies. It has a 13 members countries and relations with 17 centuries. Okay, it creates legally binding agreement. Legally binding agreement, it does mean both parties would be having obligation which they both have to fulfill. When it says that legally binding, that it does mean when you're not going to follow it, so it would be having the harsh consequences. Okay, international institution of the unification of the private law. That is what it is. UNITROIT is an independent intergovernment organization, has 61 members countries, has 3-tier structure. The secretaries carries on day-to-day work. It's run by the General Secretary. The governing council, they basically look around governing or majorly overseeing or overall managing and controlling the function of the UNITROIT. And then it would be having the General Assembly. They basically make the decisions for the UNITROIT. So there will be 3 bodies. The first one is General Secretary, who look for the day-to-day operation. General Assembly, who basically make the decisions for the body, and the Governing Council. Then we have an International Court of Justice. It is a sub-body of the United Nations. It is not a court for an individual. It hears cases between 2 nations. It includes 15 judges. No 2 judges can be of the same nationality. Okay. So this is basically the subsidy of the United Nations. These are different bodies. Okay. These are different bodies. 1, 2, 3, 4, 5, and then we have a 6. This is a subsidy of United Nations. There is one more thing I will be making it clear for you. I will just check on that. Like among these 6 bodies that we have a discussion about, which are exactly the sub bodies of the United Nations, because this is something I still have to confirm on, and I will be giving you the same after the break. Okay, I will get a search over the same thing. But before that, let's move ahead and look around the other bodies that we do have. The United Nations Commission on International Trade. So basically, this is another body that look around or that works not against with the World Trade Organization. And if we talk about the International Court of Arbitrations, so IC is a body set up by the International Chamber of the Commerce. So this is a sub body of ICC. So this is a body basically who is regulated by the ICC. This comes under the ICC to oversee all aspects of the arbitration process when members refer dispute between them to the arbitrations, right? Hello, guys, are you there?
Yes, sir.
Little weird topic, huh? But you will find more like this in your law paper. But something you have to remember the key, and that can only be possible after going through or giving a constant revision, okay? But just in a case if there would be still any doubt, so you can ask me in the class as well, or in the live or in the WhatsApp group as well, okay? But to learn them, a constant revision will only help you out. And try to memorize them by making a theory. Just think about that International Code of Justice. So what is an International Code of Justice? So what they will be talking about? Code of Justice, right? So make a theory or imaginations, and it will help you in getting the things done. Okay. Then we have United Nations Commission on International Trade. So this is another body that you have for the trade overseas, as in trade regulators, that works with your World Trade Organizations, right? Operation of the court. Court are where legal disputes have historically been settled. In a court case, parties present their claim before judge, or sometimes jury is basically the group of judges. So have you seen any of the American movie where the donkey route has been followed? In a donkey route, there are a couple of judges who are sitting together and they are forming or helping judge in making a decision, right? So when the different judges together, or basically different or more than one just sit together just to form a decision, is basically known as a jury, okay? And this is basically used as an to guide or to form a decision or to rule out or to give or award something like a resolution when there is a ongoing case. So parties present their claim before a judge or sometimes jury of ordinary citizen who decide the merit of the case. Merit means the result, okay? Parties are often represented by the legal personnel such as solicitors and barrister. So these are the people, probably can also known as the lawyer, okay? A jury is a group of regular people who help decide if someone is guilty or not in the court cases, right? Sometimes the possibility of judge getting biased would be there. In that case, you basically look forward to calling a people or the general people who might be incorporating, having some common sense, and they would be giving their decision or helping decision on the basis of the moral values, right? Parties have a right to appeal to the Supreme Court if they disagree with the outcome. This is something what happened across around the world. The common thing, but probably the structure of the court would be different, right? The main advantage of going to the court is that it can provide a helpful legal solutions. The disadvantage that are choosing to the court can be expensive and time consuming. So a question would be there in your paper. It would say what is the advantage, the main advantage, not an advantage, the main advantage. So there would be a different thing when they talk about what is an advantage and what is a main advantage. So this two word itself can make a difference. If they talk about the main advantage, so you have to talk about that they can provide the legal solution, helpful legal solution. And this advantage would be the one to be choosing, or choosing a court would be expensive one and time consuming, right? The cost of legal representation coupled with the court fees can act as a deterrent of going down this route, specifically when the case may proceed through the appeal court, right? So deterrent means something that is stopped. Okay. Hello. Is it okay?
Yes, sir.
Arbitration is one of the
Yes,
example. Arbitration is one of the example. What is collectively called as an alternative dispute resolution, that is an ADR. It is the way of settling dispute without going to the court. Either you are going to the court or either you are going to the arbitration. See, this is basically the rule. This is basically the line that we say. by referring to the issue to the third party for the resolution. So the third party that they are referring will be known as an arbitrator, right? Okay. Now onward, we will be learning a detailed discussion about the arbitration from here to now. And this is the last area of the topic that is left. Is there any doubt that you would like to ask till now? Guys,
No, sir.
something? Were you able to understand? Have you got your job? What you have to do?
Yes, sir.
So ICA, that is a body of or something that is dealt into through the ICC, that is the International Chamber of Commerce, right? Now we will learn about the international commercial arbitrations. In a globalization market that currently exists between various countries with diverse policies means different countries would be having their different policies, right? And laws, there's a high probability for dispute to arise between the traders. To resolve such dispute mutually and peacefully, the parties to trade may agree. This is something depend on the parties, either they want to go to the arbitration, either they want to go to the court. Okay, may agree to seek the impartial committee called arbitration committee. Impartial committee means that is are in the arbitration. Later on you will learn that this is more of little bit informal in comparison to the court. Okay, this committee will help find a amicable. It does mean that friendly, peacefully, specifically when resolving disagreement and mutual solution to the problem through a discussion to the dispute. Okay, arbitration agreement. Under the agreement, parties to the agreement agree to seek arbitration for all or a specific dispute which exists or could exist. So it could possible there is a contract, and in the contract there's term and condition. On those term and condition, if I have a doubt that on this agreement, on this term and condition from the agreement, I would be having the dispute with the party. In that case, I can go for what? I can go for the arbitration just to get the dispute resolved. Okay. Now the problem is that I can go for this specific thing or I can go for whole contract. Okay. The agreement may maybe have a clause in a contract or a separate agreement. Okay. It does mean that the agreement which you are making might have a clause in itself that if anything happens, so we will go to the arbitration. We will not go to the court. It has to be in writing. If the agreement is there, so it has to be the writing. You cannot say that, okay, we had discussed that if anything happens and we will go to the arbitration. No, it should be in writing. If this is going to be included, then it should be in writing. First thing. Second thing is that it could be possible that when you have not agreed, but when you want to go later on, it could also possible. But if you're going to include this into the agreement, it should be in writing. And that is signed document, exchange of letter and fix or any material evidence, right? By exchange, it does mean that both parties should know that there is an agreement, and inside the agreement, the arbitration process becomes applicable. Okay. There are certain basics you will learn about the arbitration. There's one more thing I want to say. Like you're able to see from here to above, you were having some of the bodies. They were like close to 8 bodies that you were supposed to learn. Apart from those 8 bodies, the next topic that you're learning about the arbitration. So half chapter was about the bodies, right? And half chapter about the arbitration. And surprisingly, it would be better if you understand that arbitration is altogether a different topic that can come for 5 to 6 marks in a paper. and the bodies might give you 2-3 questions, the 4-5 questions that could be vary to 6 to 7 questions. So I can say that this chapter would come from 8 to 10 marks. Okay, so just to try to understand and just try to learn and remember the key words or the key pointers from the bodies and know the concept of the arbitration, right? If anything happens, do let me know. So under the article 1.3, that is 1.3, okay, and arbitration is international. So basically it could possible, they are talking about it when the arbitration will be international. Now why we are talking about that, why we are even considering that arbitration is an international or not, why we are considering that? First thing is that it could possible that in a same country, arbitration can be appointed, arbitration process can be appointed or can be been through with two peoples when there's a dispute in a single country. It could possible, but when we're talking about the international law, so the arbitration to look after whether the arbitration is an international law or not. So these are the certain things we look around. Under the article 1.3, arbitration is an international if at the time of conclusions of the arbitration agreement, both parties should have their place of businesses in different states. So when the different countries would be having the same contract with each other, and when they're coming from the different side of the state of the countries, and when they're going through the arbitration process, and when there is an arbitration agreement, and we do see that these are the two different countries that will be known as in the arbitration that is taking place, or that is an international arbitration. Arbitration is basically the process. So they are the keywords. Process. The person who do this is known as an arbitrator. In a single own country, it could also happen, like in a same country, this could happen between the local people, and that are probably be known as in tribunals, right? If the arbitration is a process and that is happening over the international market, so how we will know whether this is the process that is taking place at the international market? So we look around the two things. When two countries are coming with the same contract when they were having, so this will be incorporating the two different countries, two different nations. This is because it is an international arbitration process. Okay, first thing. Second thing, if the parties to the contract expressly agreed that subject matter deal with the multiple countries. Expressly means something you specifically write in code. One thing would be expressively, when you expressly write it, and something would be implied. Implied means these are assumed. Even if you are not writing the implied one, so they will be assumed that they exist. Expressly, it just means something you have specifically written. So expressly what is written will be always given privilege over the implied. Okay, across your all subject matter of the law. A substantial part of the obligation exists in different state than of the properties. Under Article 3 of any written communication will be considered deliberative. So what they mean to say, under the Article 3, if you're going to communicate anything and that through the written medium, it will be considered delivered if it delivered to the address properly, it delivered at the party's place of business, habitual resident or mailing address. Sometimes what happens, habitual address is basically the person who is mostly live at which place. Sometimes you see a person who do not live at their home, they have a other place, something like that office, or other than an office they might be having other place, something like club or what. If you're sending those arbitration process letter to someone habitual place is basically the one where the party is basically living most of their time. Okay, it could be the office, it could be the home. If the party place of business, habitual resident, or mailing address can